And now it's time for another case law update. We next turn to Moloaa Farms LLC versus Green Energy Team LLC, a case coming to us out of Hawaii. This case centers around whether an option agreement for a biomass power plant was enforceable. Now, my pronunciation is not the best on some of these names, so please forgive me. Green Energy is the company behind a closed-loop biomass power plant in Koloa, Kauai. Moloaa owns almost 600 acres of land it leases out. Green Energy was partially owned by Jeffrey Lindner, who was also the sole owner and manager of Moloaa. As part of a loan agreement, Green Energy needed to demonstrate to its lender that it had secured sufficient land for its biomass operation. Green Energy proposed an option to lease agreement to Moloaa, stating that Green Energy would only enter into a lease agreement with Moloaa so that Green Energy could satisfy its loan agreement. Green Energy's counsel sent a draft option to Green Energy and Moloaa, but noted that essential terms were missing and needed negotiation. Lindner, representing Green Energy, wrote in an email that these terms didn't need negotiation, as Green Energy didn't need the property for the loan agreement since it was looking for land elsewhere, and Moloaa didn't want to commit to a long-term lease. Despite this, both Moloaa and Green Energy signed the final copy of the agreement. However, the proposed lease attached to the option agreement did not include key terms that Green Energy's counsel had pointed out. In 2013, a year after signing the option agreement, having not secured other lands, Green Energy gave Moloaa written notice of its intent to exercise the option. Lindner, this time representing Moloaa, sent a signed lease to Green Energy. In the lease, Lindner changed the effective date to the date Green Energy sent its written notice. Green Energy disagreed with the effective date and did not sign the lease Lindner sent. In return, Moloaa filed suit against Green Energy for breach of contract, arguing that Green Energy exercised the option but refused to execute the lease. Green Energy argued that the lease lacked essential terms and was unenforceable. The district court ultimately sided with Green Energy. Moloaa appealed, and the appellate court sided with Moloaa. Green Energy then appealed to the Supreme Court of Hawaii. The Supreme Court ruled in favor of Green Energy, concluding that the lease lacked definite terms and that neither party intended to enter into the lease. Let's discuss why. First, the court stated that for a lease to be enforceable, the contract must contain specific, unambiguous, and essential terms. As discussed above, the parties knew that the lease lacked essential terms, but chose to proceed anyway. The court held that because the parties left timing and pricing provisions open to negotiation, the lease lacked definite terms and was unenforceable. Second, the court held that the parties did not intend to enter into the lease. To establish intent, the court looked to early communications between Green Energy and Moloaa. For Moloaa, the court examined Lindner's email, in which he argued that the essential terms didn't need negotiation, and Moloaa didn't want to commit to a long-term lease. For Green Energy, the court mentioned it was Green Energy who pitched the idea of an option, and that Green Energy would only exercise the option to satisfy the loan agreement Green Energy had with its lender. Because neither party wanted nor intended to enter into a binding lease, the court held that the lease was unenforceable. Overall, because the lease in the option agreement lacked definite terms and neither party intended to enter into a binding agreement, the court upheld the district court's ruling in Green Energy's favor. So why does this matter? Options on real property, be it a lease or a sale, are pretty common. Often, the parties can be in such a hurry to get the option secured that they don't take the time to fully negotiate the underlying agreement. Just know that if you skip over essential terms, you may not have secured the option like you thought you did. That's all for today. I'd like to thank Frances Warden, a law clerk in our Denver office, for her help on this update.